They're going to come in if they have a workers' comp first report of injury form. There's a good chance you might get an inspection from Virginia OSHA.
Which means you might want to tighten up your ship.
Yeah.
Because they're coming. I started from my basement as a contractor and eventually grew it to 18 states and 173 million in sales. Booyah, baby! Either the next guy's going to win the deal or you're not going to get the deal.
The velocity of information through your company. We understand that this is valuable stuff.
I think the contractor should be talking directly to the carrier because they're doing the work. You know, branding yourself as being an expert, and you create your own following.
It's the nightmare of being a small business owner. You just happen to have found this amazing niche.
Hey guys, Anthony Medico SVG here, live in the Speakeasy. Today I got Ed Foulke. I say that right?
Ed Foulke.
Ed Foulke. Sometimes I mess up the last names. Ed was former chairman of OSHA.
The Review Commission.
The Review Commission at OSHA. And assistant
Secretary of Labor for
Assistant Secretary of Labor for OSHA. Under President Bush.
Both Bushes, yes.
Both Bushes.
Yes.
So that's quite a pedigree. So I brought Ed on. He's going to actually be a speaker / trainer at the Win the Storm conference in Phoenix. So him and I have been chatting. I thought it'd be nice to have you on the Speakeasy, kind of introduce you to the guys and gals out there in the contracting industry.
Right.
So now you're actually in a law firm based out of Atlanta.
Correct.
And you represent employers,
right,
like contractors.
That's right.
That are facing fines or safety situations or violations.
You know, we do kind of help clients understand what the rules are, what OSHA regulations require of them, and that's hard for a lot of particularly small and medium-sized employers because they don't have the ability to have safety and health professionals on staff full time. So we kind of help advise them of what their requirements are, what the legal requirements from OSHA are, and then when they do have inspections, if OSHA comes on their sites. And we assist them in providing, explaining them what their rights are during the inspections, assisting them on handling the inspection. And then after that, if they do receive citations from OSHA, then we will defend them, help contest those citations and defend them at the Review Commission.
So just in a nutshell, it's probably best to have somebody help you out in a defense situation that's actually on the OSHA side, the federal government side. So you've probably got an inside peek or look at how to maneuver and get through that process with the least amount of liability, I'm assuming.
Right. Well, when I was the head of OSHA, I oversaw all the different regions and the area offices. So they're the ones who are responsible for conducting the inspections. And then when I was at the Review Commission, I actually helped draft a lot of the case law that was associated with different citations and what you had to prove and what you didn't have to prove, and so.
Now, Ed, you were an attorney before you worked for President Bush, or after, or?
Yeah, I was attorney both times I was in Washington. The first time was when I was chairman of the Review Commission, and that was under Bush 1 and 2 years under President Clinton. And then when I was head of OSHA, it was under W, what they call 43.
43, the son
of
George.
Yeah, so that's where I was running the agency.
So it's interesting. So now your law firm is Fisher Phillips,
right?
Correct, out of Atlanta. And so now you're helping contractors and employers in any industry that have OSHA violations or safety concerns or compliance issues.
Yeah, if they have an inspection, if OSHA shows up at the door, and a lot of employers don't realize this, that you actually have certain things. If certain events occur, that you have to contact OSHA, you have to call OSHA. You have an affirmative duty to do that. And one of them is if you have an if you have a work-related fatality, then you have 8 hours in which to call.
8 hours.
So.
Or you get another fine.
That's right.
See, I never knew that.
Yeah, that's right.
I was telling you earlier, I ran across 18 states in 13 years as a GC and a roofer, and I didn't know any of these OSHA regulations that you were mentioning earlier.
Right.
Very few. I think very few people actually. 80% of the market out there. Probably.
And that rule was changed back in 2016 during the Obama administration. But they also added there that if you have the hospitalization of one employee, and that means the actual person admitted to the hospital and is not there for diagnostics or observation, then you have 24 hours to contact OSHA.
So for example, even here in a regular office environment, if a gal or guy slept, got a concussion, got to get sent to the hospital, I actually there's a regulation, I have to call OSHA and notify
If
OSHA.
they spend the night and they're getting medical treatment, you have 24 hours to call OSHA after that you become aware of the event.
See, I learned something new, I didn't know that.
So,
Don't go to the hospital, Kyle. And then there's another one. Now I had an incident back in 2005. We only had a couple accidents over those years, surprisingly, because we didn't do a lot of safety training like we should have. A lot of folks don't because they don't know what that safety training
well, a lot of
consists.
small employers don't because they just don't know what they're required to do. They want to do the right thing. They do want to have their employees safe, but they just don't know what to do.
Right. And this was it was a roofing subcontractor. However, in Florida, a roofing subcontractor is really an employee.
Right.
Because you got to put him on some kind of payroll to get the workers' comp. So theoretically, he was legally an employee, although he was a sub. Lost his thumb on a standing seam metal cutter, and now that would actually be a reporting requirement.
Yes,
even if it's the tip of the thumb.
Right. If you just lose your fingertip, there's no requirement for a bone loss, and then you have once again 24 hours.
24 hours
to contact OSHA, and if you have an amputation, more than likely they're going to. I would say probably 98% of the time they're going to show up because there's a national emphasis program on amputations by OSHA. So they're very much focused on that.
Now, over the last year, I've noticed just a little bit more in the last year, a lot more accidents in the newspapers. Some of our clients, a lot more OSHA fines in the last year. Is it a beefed up OSHA as a result of this, or what's going on that's causing that increase?
Well, the enforcement. Unfortunately, there's been no new assistant secretary appointed during the Trump administration. So it's been a little disappointed in that respect. And so there's no one really there kind of be able to direct there's an acting person there, but they don't want to go and do things that they should be able to do if there was a full-time person there. So I think that's a lot of what's happened is you're still seeing a lot of the holdover of the Obama administration, and part of that is the enforcement focus. And so you have more inspections being done now by OSHA than were done during the Obama administration.
Wow.
So.
Yeah, I've just recently heard about a lot more this last year.
Yeah, and there's a lot of focus on particularly construction. Fall protection has been a big issue. Roofing seems to be. I'm seeing more and more inspections being done involving roofers, and unfortunately, there's been some where they've had fatalities, and obviously, OSHA is very much focused on that. So, if you don't have the right fall protection program in place, you're going to get cited for a number of issues, and so that's going to be quite expensive because, particularly if they think it's willful or if it's a repeat.
Gross negligence, just not caring.
Yeah, willful. Yeah. And if it's a willful violation, you're looking at over $135,000 for one citation.
For one citation.
For
$135,000.
Yeah.
That could put a dent in someone's cash flow.
Yes, you can just think about that if you just get several citations because the standards. Let's just look at the fault protection standard. You have a whole series of things that you're required to do if you're a contractor on fault protection. And if you don't meet those, then each one of those provisions in the standard could be cited as a separate citation, and thus potentially another $136,000 per each citation. So it wouldn't hard to get to $1 million in penalties fairly quickly.
Wow, and that could put somebody out of business if you didn't
man.
have your stuff together. How is let's back up and talk about, because I learned something new earlier talking today, how OSHA is actually set up on a federal versus a state level.
Right.
Because it's two different levels, correct?
Right. When the act was passed in 1970, there were federal OSHA covered the entire country. But in the OSHA Act itself, there was a provision to allow states, if they wanted to take over safety and health in their state. And a little over 20 states have opted to do that. And so there's what they call state plan states. And they have the same regulations, in some cases more stricter regulations than federal OSHA for their employers. And requires some things that OSHA doesn't require at all, like California, Oregon, Nevada, Washington State, all have what they call injury and illness prevention programs in their state plans. Well, that requires employers to have an overall safety and health program in place.
Like a written manual of some kind?
Some type of policy there, a safety policy in place, which is supposed to include different things, but one thing they all include is you have to have a safety committee. Now, there's no requirement in federal OSHA to have a safety committee, but the state plans, these different state plans are required to have a safety committee. So if you're operating in different states, you have to know what the rules are for the different particular states that you're in.
So again, in a nutshell, you could have a much stricter state OSHA committee or OSHA regulations you could at the federal level, and you really need to know what those states are.
Right.
Maybe we can get a list of those from you later.
Yep, there's like I said, there's a lot of different. Each state has different things, but for the most part, they've adopted the federal regulations, and then added on to the things that they had.
Now, the one where the safety manual is supposed to be on site, is it on site at the office, or is it on site on a job site, or just somewhere in the office?
They just have to have a policy. They have to have a safety health policy and be able to, and that's going to, it's not going to necessarily be a manual as opposed to just a policy, but it's going to spell out certain requirements about having this safety committee.
Maybe meeting once or twice a year, or once a quarter?
More like once a quarter.
Once a month, once a quarter.
So, well, it depends on the state.
Right.
But it does that. But it also requires you to have certain other things that maybe doing job safety analysis, which Fed OSHA really doesn't require. They encourage, but they don't. There's no specific written requirement.
You said California is definitely one of those?
Yes, California.
Well, Florida.
Florida is a federal state.
It's federal state.
Federal state.
I'm surprised. They like to control a lot of stuff at the state level there, just from my experience. But that's interesting. So there's a lot of compliance stuff going on. A lot of these guys watching this might be in those 20 states. They might not have any clue that they need to have some of this stuff. For example, we were talking about roof substrate materials like hot tar. Certain chemicals need to have an MSDS sheet on site.
Yes, safety data sheet. Yes,
Safety data sheet.
SDSs. That was when they moved from the material safety data sheet to a safety data sheet, and that was a change in the hazard communication, OSHA's hazard communication standard, which changed what was in the safety data sheets, and so the new requirements have actually 16 different parts that have to be included in the safety data sheet, which was not required in the past. It was kind of allowed to the manufacturers of chemicals to decide what they put in their safety data sheets.
Mm-hmm. So if let's say I'm a contractor, I had an incident on site, OSHA came and did an inspection, I'm in one of those 20 states, and they had some stricter guidelines, I could get cited for the accident. I could get cited for not having safety data sheets on site.
Right.
I get cited for not having a safety committee set up at my office with some kind of safety manual.
Right.
And maybe some kind of record keeping of having a safety meeting once per month or once per quarter.
Right, and maybe even on personal protective equipment, having certification that you've actually done a hazard assessment on your work site to determine what PPE you actually need.
Or that you had fall protection, or if it's an accident related to fall protection, perhaps somebody fell off a ladder, that you had no record or documentation of a class being provided, correct?
Well, some type of training.
Some type of training.
You got to be able to show that you had proper training. So
just a lot of moving parts. Now, do a lot of these regulations change every year? But have they been static for the last 10, 20 years? Or?
Well, they're not really revised. It takes so long for an OSHA standard to even get into play or even get to be placed into a formalized standard. I mean, it may take 8-10 years for an OSHA standard to get through the whole process. So it's not that they do. They do some updating. The record keeping one was one that they did, and that's when they added those time periods. They changed the time periods and added new categories to report to OSHA. So that was a focus to help OSHA on its targeted inspection, really.
Now, how does an OSHA inspection take place? Because a lot of guys are, I hear, we see them on a page, OSHA came by, right. I think my competitor must have called them, or, you hear this goofy stuff. How does an OSHA inspector...
I don't know if that's too goofy, but it's because I hear that all the time from my clients, that they think that some of their clients have contacted them. But generally, there's different ways that OSHA can come in. OSHA has to have a reason to be there.
So that probable cause.
Yeah, they can't just stop and say, I'm going to go see that plant over there. I'm just going to go in. I just want to go see it. They can't do that. They have to have a reason, a specific reason, have jurisdiction to come into the plant. And that's one of the is the ones we just talked about, the call-ins. If you do what they call self-referral. If you call in because you've had a fatality or a hospitalization of one employee or a fatality or an amputation, then you're going to get more likely particularly on amputations and fatalities, you're going to get an inspection. So OSHA will show up on that. If you have an employee who files a complaint, they then that's what they call a formal complaint. If that person's willing to come in and sign something, a statement to OSHA about that safety hazards or violations that they think they're there, then OSHA will come out and do an inspection. That's called a complaint inspection. So they also have what they call special emphasis programs or emphasis programs, and that's where they focus on different types of industries, like in construction is what they have.
Roofing's probably a big one.
Roofing is one there. So there's different emphasis programs. If it's one of those, then OSHA has the ability to come in. But if they show up, the employer needs to know that they need to be asking, why are you here? So that they can determine, do they actually have jurisdiction? I'm contesting jurisdiction up in Virginia right now on a case. Up there, Virginia OSHA, that's a state plan state. They have a provision in their rules, which is actually codified in the state statutes, that requires the Workers' Comp Commission to send to the Department of Industry, Labor and Industry, all their first report of injury forms, and then so those get audited. Then they go to the Virginia OSHA, and if they meet certain criteria, they're going to have an inspection. Surprise inspection, or is it scheduled? No, all of them. Well, it's pretty much they're all unannounced inspections. Unannounced, okay. Right, because there's actually a criminal provision to to give information about an inspection, someone coming on. So if you have an accident, let's say in Virginia, you're going to get audited, you're probably going to get some kind of inspection. You're going to get an inspection. Okay. There's a good chance of that. They're going to come in and inspect you. Now, are all state OSHA plans like that, or is it just certain ones? That's a unique, that one on the workers' comp is unique to Virginia. And this one's just come up recently, but it's the idea that they're going to come in, if they have a workers' comp first report of injury form, there's a good chance you might get an inspection from Virginia OSHA. Which means you might want to tighten up your ship. Yeah. Because they're coming. Well, you get your safety manuals, you get your stuff set up, so when they come, you have a little less liability. Well, if you call OSHA, if you fall within those categories where you have to call OSHA within a set time period, well, more than likely they're going to show up. Right. And so you need to be preparing to have this inspection, know how to handle inspection. And that's another thing that I find, that most employers really don't know what to do when OSHA shows up. And they're probably like, oh shit. Yeah, well, and they do a lot of that, but they really need to understand what their rights are during inspection, because employers have rights. And how to handle the inspection, making sure that they're taking the photos. If OSHA's taking photographs, they should be taking photographs. Right. If they're going to be doing monitoring, well, we're going to do side-by-side monitoring. Because it could turn into a criminal thing. Correct? Well, if you have a fatality, you have to have a fatality to have a criminal action. So the test for a criminal referral to the Justice Department is that you have a willful violation of an OSHA standard that results in death. That's the test. So, have you ever seen anybody go to jail for that? There are people that go to jail, yes. Okay. But the more likelihood of someone going to jail is if they tamper with or alter evidence, or they get false testimony. That's where I see people go to jail. OSHA doesn't like that. Neither does the Justice Department like that. So I'm assuming your firm now, Fisher Phillips, your law firm, probably gets a lot of calls from frantic contractors or employers. They're like, "Hey, X happened. Somebody died. Somebody got hurt. Right. They're on their way. What do I do now to get prepared?" And that's what we do. We kind of give them all the do's and don'ts. Tell them how to handle the opening conference with the OSHA inspector. Document production. OSHA's not, depending on the type of inspection it is, if it's a complaint inspection or if it's a self-referral, it's going to be limited just to that particular machine or area or whatever product site. But it doesn't open up. So they shouldn't be walking around the other side of the plant? No, they should not be allowed. No, okay. And that's very important. Unfortunately, most employers let OSHA do that because they don't know their rights. So they might ask them and say, "Hey, do you mind if I go check out your..." Well, they might just start walking over there.
And they're not supposed to.
No, that's right.
Okay.
You gotta, well, you set those ground rules up at the opening conference, as how you're gonna handle the walk around, how you're gonna handle employee interviews.
Sounds like it's a good idea to have an attorney firm like yours there when this happens.
Yes, it's better to have, you know, I don't wanna sound self-serving, but it is better for us to be there, or at least be on the phone, talking to them in order so that they understand that, you don't give them every document they're asking because they're not entitled to every document, because if you do that, you may open yourself up.
Another can of worms.
You know, if they're gonna be interviewing manager or supervisory employees, then we're gonna make sure that another member of management's there to take notes. And we'll actually probably talk to them a little bit about how to handle these interviews, and what's the person who's being interviewed, what's their rights, and that's very important. And then providing documentation. Some employers think if they give them everything they got and tell them everything they know, then somehow that's going to make everything well, and it doesn't. It always makes it worse.
Ultimately, it's probably best if guys got trained up, knowledgeable about some of this stuff they're supposed to have in their offices and their training ahead of time to help mitigate actual accidents, but also help mitigate the consequences of once they come and do this inspection.
Right. You can't. It's hard to handle inspection once OSHA shows up. So you got to plan in advance. I mean, there was a case that when I was head of OSHA was involving a explosion that killed 16 people down in Savannah, Georgia. And
Chemical plant or?
No, it was a manufacturing plant, a combustible dust issue. But anyway, so we had, that's what I could say, when I was head of OSHA when this occurred, we have an office, OSHA has an office in Savannah. Well, so we were on site within an hour of the accident. We were there before most everybody else is. So but.
Oh, you were with OSHA or as the attorney firm?
No, at that point that's when I was head of OSHA.
Head of OSHA, okay.
So we had and this kind of shows why you got to be able to plan in advance, because OSHA showed up, or my guys showed up, and then of course they already had the fire department there, they already had the police there, they already had the EMTs there, they already had the media there, and so they're trying to deal with all these different groups.
Right.
And then the next group that showed up was ATF, alcohol, tobacco, and firearms, because there was an explosion, so they come in on any type of explosion, and they check to make sure that was a terrorist event. So they cordoned that whole thing off as a crime scene. So that was kind of interesting dealing with that. Then the state EPA showed up.
Does that mean they can hold OSHA back till their investigation?
Yeah. But they also, the state EPA showed up because this particular facility was right on the Savannah River, and so when they were firemen putting out the fire, all the water was going into the Savannah River.
Oh, jeez.
So that was an EPA issue. And then the next day, the Chemical Safety Board from Washington, D.C. shows up. So that's why you have to plan in advance, because here, look how many, you're talking about 6, 7, 8 different organizations or agencies, federal governmental agencies, showing up, and you're having to deal with them. So it's very important that you have plans in place, have an emergency.
To have it in advance,
right?
Correct. Yeah, to have that relationship and that.
Well, and just have who's going to handle what. If OSHA shows up, who's going to be responsible for handling the OSHA inspection?
And now your firm now services what? 30 states, 34 states.
We have we service all the states, in that we do work along with all 50 states, but we have 33 offices around the country. So.
Yeah, because you got like 30 attorneys on staff, don't you?
Well, with respect to the OSHA practice group, we probably have more attorneys. We have over 30 attorneys that do OSHA work.
Just the OSHA.
Yeah, so we're the largest OSHA practice group in the country.
So you're able to help probably a lot more employers than a lot. Is there any other firms your size that deal on the defense of the employer when they're dealing with OSHA firms?
Oh yeah, there are other labor and employment law firms and general practice law firms that have OSHA practices, but we like to think that we have the more sophisticated practice group. We're doing more of the high-end stuff, so the more complicated legal stuff that employers may.
Now, to that manufacturing plant, I'm assuming they got a few fines, it sounds like, with all that stuff going on.
Yeah, I'm trying to remember there, and there was some question about criminal, but I don't think they never did move. The Justice Department never went forward on anything on that, but yeah, they received it. And the plant was shut down for 6-7 months.
What do you think the biggest stumbling block is? I mean, I kind of know my market. Now, you're looking across all industries from an OSHA standpoint. We deal with roofing contractors and general contractors, so I kind of know with my group, because I was one. I mean, I'll shamefully say I probably hired several hundred salespeople, for example, over a period of 13 years.
Right.
And they would put up ladders on roofs. They're climbing up and on roofs usually within 1 day of training, which was usually a PowerPoint type training in the office. And we didn't go out and make sure, because I didn't know. I knew they had a bungee cord off the deal, but I didn't know how far the ladder back should have been at the base.
Right.
There's certain things I didn't know because I just didn't read up on it. And I think there's a lot of contractors out there, some watching this right now, that don't know themselves some of these rules. And the ladder's the easy one, some of the fall protection rules, all that. Right. And if they do know, they might be running across 3 states, 2 states. They might have 15, 20, 30 guys and gals running out there. And they're just not effectively training them to make sure they know. And they certainly don't have documentation in their office of such things. I don't know if this is the same across all industries. What are you seeing out there?
Well, I think it is across all industries. I mean, first of all, the small, medium-sized employers really just don't understand, don't realize, or are not knowledgeable what safety regulations apply to them. Mm-hmm. And that's not surprising when you think about it, because every day during the week, every day I receive an email with the Federal Register for the day, and in there I can check to see if OSHA has promulgated any new rules or regulations, because that's where they have to publish it. Mm-hmm. But no small employer, medium-sized employer could do that on a daily basis.
And they might not even have time, even if they did.
They wouldn't have time. Yeah. Well, they probably wouldn't have time, and that just goes to the point. It's really almost impossible for every small, particularly small and medium-sized employers, to know all the regulations that are required. And so that's kind of where I help them, knowing what's applicable to their specific industry or their specific company. Excuse me, because there are certain regulations that apply only to certain company or certain industries. And the OSHA regulations are split into different groups. You got general industry, which does apply to construction and maritime, but then you have specific construction standards, and then you also have specific maritime standards. So there's so those are going to be only applies to shipbuilding. So those are going to be those specific industries are going to have made additional things they're going to need to be doing in order to comply with those other regulations.
Now your firm's launching this new program I saw, which I thought I was thinking about this a year ago. I'm like, man, if there was a way to create a preventative, right, a proactive safety program where contractors could actually train their teams. Of course, I'm thinking virtual training, because you're showing the virtual training, or certify, test out, and that way they can actually train. But your company actually launched Safety Solutions. Is this a preventative, proactive program to help small businesses?
It is intended that, it's going to happen to all businesses. Really, it started out in its roots on what we were talking about, ISO 45001. This is the new safety standard. It's an international safety standard for workplace safety health. It's a risk management system. It's as I mentioned to you when we were talking, it's going to be, in the next 10 years, probably 60-70% of the companies in the United States are going to be certified in 45001. And the good thing about it is that when we designed, and I was on the technical advisory group for the United States that helped draft this, with there were 70 countries that were involved in writing the standard. But when we wrote this standard, we intended that a small employer could be in 45001 just as easy as a large employer. So it's by scale, size and scale is how we set it up. ISO 45001 is going to take companies, and it's going to take companies that have good safety programs and going to eventually get them to world class.
And they'll have some kind of stamp or certifications.
Well, they'll be certified in ISO 45. There's certified agencies or groups that are out there that are going to be certifying this once they able getting to the proper position to be able to be certified. Because most employers right now do not have everything you need to have to be in 45001. And that's part of
most of them probably have no clue what those things are.
No, and that's what we set up. That's what we set up Safety Solutions to help employers that wanted to get into 45001 or are going to be required. Because if you have clients, if your customers are European based, you're going to be in it.
Because they're going to require that
the Europeans are already moving very quickly. As a matter of fact, some of the European governments are looking to make this 45001 mandatory. for at least the large employers. So they're going to be moving in that direction. If you
And that might pull all the small businesses with it.
well, it is going to do it because they're going to the companies are going to want their vendors and suppliers and contractors to be 45,001 because they want to have companies that working for them that are safe. That's very important to them. And if you're out of Canada, they're going to be moving on to 2. If you have clients that are Asian based, particularly Japan and Korea, you're going to be in it down the road. There's just no doubt that they're moving very quickly. All the transplant automotive companies are all moving to get into 45,001, and then they're going to be driving it down to all their vendors and suppliers. So this is going to it's going to help companies have great safety. It's going to end up saving them a lot of money. It's going to help them be more profitable, more competitive, more productive.
Now I showed you today the basic,
Right.
which I did. And I'm not an OSHA certified instructor, but we did it by the book. The basic OSHA, the basic OSHA ladder requirements, how to set up a ladder properly. That was one chapter with the testing and a report card. And I think you and I had some bells going off there on what we could probably do, not just with roofing and general contractors, but through virtual training and testing and automated report cards, how an entrepreneur, small business owner across any industry could actually really reach all their employees across multiple states or multiple facilities and get that training that you guys provide in a very fast, efficient manner.
Yeah, and training is essential to be able to demonstrate OSHA compliance. It used to be that all the OSHA standards had a documentation requirement, and that changed during the Reagan administration when they passed the Paperwork Reduction Act. And so all these agencies got gold stars for reducing paperwork, and OSHA
It's not to be digital.
Yeah.
Yeah.
And so OSHA did the same thing. They didn't require it in the standards anymore, and they actually took it out of the standards. But when OSHA comes in and inspects you, and they're asking you about, well, what training did you do?
Right.
Well, so we trained our employees. Well, they're going to say to you, well,
Where's the proof?
That's right.
Where's the proof?
And so
guys, what we're doing, and we're going to continue to talk to Ed and his firm about it when we come out to Atlanta in 2 weeks. But SVG is moving into this safety courses on digital because it does meet the requirement, and silly things like the safety sheets that you're supposed to have on site that nobody ever does for all the different chemicals. We can keep those in a virtual file, and that's still acceptable because we're going paperless, correct?
yes, but they have to be readily accessible to the employees at the site, wherever they are.
Yeah, and they are through an app technology.
Yeah.
It's 24/7 accessible. So we're excited about that, and really putting the training safety. It's not going to solve all problems, but if more people knew about this stuff, it's going to reduce accidents.
Right. There's so many small employees, like I said before, don't know what they're required to do, but they want to do it. They want to do what is right, and that's what we have to make it more accessible to them. And that was always the problem when I was head of OSHA, is trying to figure how do I get down to the small employers, because they're the hardest to reach too.
Yeah.
They need the most help, and they're the hardest to reach.
Hardest to reach, and even if you get them now, how do I get to their people underneath them? Because therein lies the problem. The entrepreneur might know some of that stuff,
Right.
but it's very hard from a daylight and timing issue to train humans, which have a very high turnover in the contracting industry, and you almost need to automate it like what we saw today.
Right.
So we're excited at working with you guys on that.
Yeah, me too.
Now, how up are you on fall protection?
I'm pretty knowledgeable about it.
Because I'm still confused about some of the fall protection. So because you caught me in a video. Now we wear some harnesses in the SVG U, like we're supposed to, but some of them when we're on a 612 one story, we're not wearing any fall protection.
Well, under general industry, of course, you'd be under construction.
Yeah, roofing.
So you have to, anytime you're over 6 foot, you have to have fall protection.
Even on a 612 one story.
Yes. Well, yeah, as long as because then you'd have to protect against the edges. So you'd have to do that. Now there is an exception. I mean, when you for roofers, if you're going up and inspecting something, but not doing work, but you're there to inspect. Say you're there to determine. All right, I'm looking at this roof to figure out what the scope of the job is going to be and how I'm
like write an estimate or
how am I going to price this all out. There, you're not required to use fall protection. That's the exception. There's an exception for at the beginning before the start of work, and then once the work is completed, you can also go up there and check it too.
But if you're tearing off and installing a roof on a typical one-story home, even a 612 pitch, you're supposed to have some fall protection.
Right. If you're they talk about pitch for a little bit, but it's more focused on if it's 6 feet high.
Okay,
But 6 feet. Well, if you're on a flat roof, you still would have to have perimeter fall protection.
Perimeter fencing.
Yeah.
Yeah.
Or lines or whatever it is.
A lot of times you see the orange flags. We just put the orange
Right.
flags around.
That's right. And they're going to be X number of feet back from the edge.
Because I could bet that 90% of the roofing contractors out there on your average 1-story 612 walkable aren't wearing any fall protection. You
Probably
can drive
not.
around and see that.
Well, and
And that's
unfortunately,
potential. You could
Yeah.
get a fine for that.
right, and very big fine. And
What is that? What is a minimum fine for something like that?
Well, it
Or
just
maximum?
depends. If it's a willful violation, let's say if it's a serious violation or other than serious, the maximum penalty is $12,700 But if it's a willful or repeat, now you're looking at 135, 136.
135,000. That's on a second one. Correct.
Well, for a repeat it would be, but for a willful, it would be the first.
So willful, you get hit with 136 first.
Right.
If it's willful.
Right. So, and that's why employers need, we work with our clients to make sure that their citations that they do receive, that if they do have evidence to demonstrate that they did not violate the standard, then we're contesting those and getting those dropped. Because if you got a citation, and I think OSHA does this a lot, where they'll cite you for it the first time, and they may cite you $1,000 or $2,000 or something like that, and say, and
Give you a slap on the hand.
and then you go to informal conferences. All right, we'll reduce that by 30%, and you sign a informal settlement agreement.
Mm.
Now OSHA comes back, and I guess another complaint or something. There's an
Now it's
accident.
136,000 on a second time.
On this because it's a repeat based on the serious or other than serious standard that you didn't contest, because even though you had the defenses to it, because it was only $1,000.
Now, would it help a contract? I'm just looking at my part of the contract industry guy, not all industries. But if guys had, and you saw a little bit about that automated testing report card. So if you had like 50 employees or 50 salespeople or 50, whatever it is, and you could show proof that they went through digital courses on ladder safety, on fall protection, would that help subjective opinion on whether something's willful or accidental?
If your employees are trained, if you can demonstrate you're trained, that
Date,
they're
time,
trained,
stamp,
they're
like what we
protected,
saw.
yeah, then it makes it really hard to have a willful violation.
So just doing that, just having that,
Right.
your people run through that program then could be evidence and proof that you're actually taking precaution.
Yeah.
Possibly waive the fine at all.
Well, I don't know if you're going to.
We still need the little- we still need the little one.
You're going to do that, but once again, you need to be ensured and what you need to have too is, or the employer is going to need, is be able to show OSHA, here's what they were trained on.
Right.
So not only here I can demonstrate they were trained on this date at this time,
Date, time,
but
stamp.
they also this is what they were trained on specifically. This is what information they were provided, and so and that way employers can demonstrate that they are in compliance with that and are trying to have a safe workplace.
Right. And that could be the difference between a $12,000 fine and $136,000 by showing that you actually had some training on site or through an automated system like what we talked about. How about now? Let's say somebody, worst case scenario, let's say a 18-year-old kid climbs a ladder, falls off, dies, right? And you have no training, and they come and do an investigation. Maybe it's one of these harder states, and you have no safety committee, no safety plan, no proof of training, no proof of ladder safety training, digital or otherwise.
Right.
What are we looking at as a liability potential?
Well, I mean, OSHA could look at a number of different standards in that particular one. The fall protection standard and the provisions within this fall protection standard. They could be cited for a number of provisions, because I've seen this where OSHA inspector goes down each of the provisions of the standard.
Right.
And if you don't have it, they cite you for that. So you might get cited for 1910 whatever A, but then also you got cited 1910 whatever B, completely separate.
So you didn't have a safety committee, you didn't have ladder safety training, you didn't have all these things.
But then also all the different types of other standards, personal protective equipment. You don't have, or you didn't provide PPE. You didn't do the hazard assessment, which is required. You didn't do this. You don't have a certification that you did the hazard assessment. That's another requirement. So all these different things are.
It's going to run into a couple $100,000.
Oh, easily. If OSHA really wants to go after the company and make an example, yes.
Right.
Could be millions.
Well, I know we gotta run into the green room here, and we're gonna shoot a couple short chapters of some basic OSHA stuff, and then look forward to having you at the Win a Storm Conference in Phoenix. That's going to be here in Phoenix. You guys know, February 20, 21, 22, 2020. We're going to have you on for one of those days to really meet the group of contractors. And then I think you and your team are going to host some breakout sessions for OSHA safety, which is going to be very valuable at the Win a Storm Conference. And if you guys can make it, we're going to be in Atlanta December 4th, Wednesday, December 4th. We're doing a lunch and learn. You're right in Atlanta, so we might have you or one of your guys at the office come over and hang out at the lunch and learn, meet some of the guys.
Okay.
Thanks for coming on to Speakeasy.
Appreciate it. Yeah, thank you.
That's a booyah, baby.